Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
Freedom of expression is the lifeblood of a free and democratic society. It protects our right to speak, to create art, and to protest. But does this fundamental protection extend to the right to sell a product? To explore the true scope of this right, we welcome Professor Richard Moon, distinguished university professor at the University of Windsor and a leading scholar on freedom of expression and freedom of religion. Today, we are looking at the landmark decision of Irwin Toy from 1989, a case that shaped the very definition of expression in Canada. In the late 70s, Quebec passed strong consumer protection laws banning commercial advertising directed at children under 13. This forced the Supreme Court to answer a foundational question. Does the Charter protect any activity that conveys meaning, even a commercial sales pitch? And if so, is the protection of children a sufficient reason for the government to silence that expression? I'm Laurence Lapierre. Let's find out together. Enjoy.
My name is Richard Moon. I'm recently retired from the Faculty of Law at the University of Windsor, so I guess that gives me the title of Professor Emeritus, University of Windsor.
Professor Moon, welcome to Shaping Canada, 150 Years of Landmark Decisions. Thank you for being with us.
Well, thanks so much for inviting me.
Professor Moon, we might be criticizing the Canadian government or give a negative opinion about our politicians. We will comment on the landmark decision from our Supreme Court and may even discuss what should be improved in our system. One of the reasons why we're able to do this publicly in a podcast is because of a specific right mentioned at Section 2B of the Canadian Charter of Rights and Freedoms. Professor Moon, what is freedom of expression?
Yeah, that's a good question, and it's a large question that I could go on at length about, but basically it's the freedom to express oneself in the public world, to express oneself generally. So in the United States, of course, as you know, they refer to free speech. And for the most part, the terms are interchangeable, freedom of expression or freedom of speech. And certainly, and we'll get to talking about the Irwin Toy case, but the Supreme Court of Canada and that judgment and courts in other jurisdictions have generally said freedom of expression protects the individual's right to communicate to others, and by which they mean to engage in some kind of act that involves conveying a message to others. So that's the basic idea of freedom of expression. Now, the right rests upon a variety of values, and we can talk about those at some point.
So let's go prior to our charter and maybe prior to 1989. Did that mean that we could not say whatever we wanted, whenever we wanted, to whomever we wanted?
No, of course not. The fact is that what a Charter of Rights does is it establishes within the Constitution a number of rights, and it gives the courts some power, some authority to hear a case, hear somebody make the argument that their right has been interfered with by the state, a state actor, whether we're talking about legislation or a state administrator of some kind. So it isn't as if there was a complete absence of freedom of expression prior to the Charter. Instead, this just creates a new form of protection at a constitutional level that involves the courts in seeking to interpret these rights and granting remedies if they determine that the right in the Charter has been breached. So we hope that even in the absence of the charter, before it came about and subsequently, that governments will honor the right to freedom of expression. We know they don't always. We know that there's a temptation sometimes to suppress expression, and that's precisely why we have this right. Now, there are also other ways in which the courts played a role in protecting freedom of expression or freedom of speech prior to the Charter. And one of them has to do with the federal division of powers in Canada. So as you know, the provinces under the 1867 Constitution have jurisdiction in relation to some matters, and the federal government has jurisdiction in relation to other matters, whether that's defense or trade and commerce, matters of that kind. So usually it's seen as things of national interest on the one hand and things of a kind of more local or regional interest on the other hand, although how that plays out is a whole other question. And something that the courts did in a number of cases, in the 1940s, 1950s, was to say that when a province restricted political speech in some way, that measure on the part of the province fell outside of their jurisdiction, out of their powers under the 1867 Constitution. The argument being that political speech was of national significance, in some sense was indivisible. You couldn't have a democratic parliamentary system nationally if speech was restricted anywhere in the country, political speech in particular. So there were different ways prior to the Charter of Rights in which the courts protected speech. It was imperfect, it was partial, it failed in many ways. But again, I return to the most important point is we hope and we expect that Parliament or provincial legislatures will honor or respect this right, and for the most part they do.
So Canadians have the right to express their opinion against anybody or against only the government? What is protected by the Charter?
Well, they have the right to express themselves more generally. Now, the right itself is a right against the government. That has not anything to do with who you're speaking to, who you're communicating with. Rather, it has to do with what counts as a restriction on the right, on expression. And so if my employer, for example, prevents me from expressing my political views, I may have certain claims or rights under ordinary legislation, perhaps under human rights codes enacted by a province or at the federal level, but I don't have a claim under the Charter. It's only when the state, a state actor of some kind, legislation we think of ordinarily, a law enacted by the government, only when that is what interferes with my freedom of expression do I have a claim under the Charter. It's easiest to illustrate this not with freedom of expression, but rather, say, the right to equality. So if the state enacts a law that discriminates against me on the basis of religion or race or whatever it might be, I have a claim under the Charter, under Section 15, the right to equality. If, however, a restaurant owner throws me out of his or her restaurant on the basis of my race or religion, I don't have a Charter claim against that restaurant owner. Now, each province and the federal government has a human rights code. It's not constitutionally entrenched, but under ordinary law, I would expect to have some kind of protection against discrimination in the service sector, for example. One of the complications around this idea that the Charter only applies to action taken by the government is that, of course, private actors like the restaurant owner can do what they do because of, say, trespass law or property laws of different kinds. And so the state is always in some way implicated, even in private action of that kind.
Section 2B is called freedom of expression, and it says everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Let's jump right away to Irwin Toy, 1989, Supreme Court of Canada. Only 7 judges heard the case, by the way.
So Irwin Toy, a toy company, challenged this law, arguing that it restricted their freedom of expression. Any kind of charter adjudication involves 2 steps. The first step is the question of, has the right, in this case, the right to freedom of expression, been breached? Has there been a restriction on expression by the state? Now, if it's determined that there has been a breach of Section 2B, that there has been a state interference or restriction on expression, then the next question is that restriction nevertheless justified under the terms of Section 1 of the Charter, which is the provision that permits reasonable and demonstrably justified limits on the rights in the Charter. So there's always, or almost always, two steps to any kind of freedom of expression case like this. First, has there been a breach of the right? And if there has been, then the question is that breach, is that restriction nevertheless justified under the terms of Section 1? The court, Supreme Court of Canada, in Irwin Toy in particular, defined the scope of Section 2B, defined what counts as expression so broadly. Most important or interesting freedom of expression cases are decided at the Section 1 limitation stage. The court often takes little time at the first stage of the adjudication when dealing with the question of, is this expression that has been restricted by the state? And almost all of the analysis, the meaningful analysis, occurs at the Section 1 stage because the court has defined the scope of the right so broadly. So what the court says is that any act that is intended to convey meaning to an audience is an act of expression that, at least, as we like to say in law, prima facie, on first glance, falls within the scope of Section 2B. Now, the court illustrates just how broad this definition is with the example of parking your car against the rules. So the court says, for example, if I object to the way, say, parking spaces have been allocated in some way, this may or may not be a government action. It could just be a private employer, but this is simply their example. They say, so if I object to how parking spaces are allocated, and in order to protest that, I park my car against the rules, that's an act of expression. Now, because I'm intending to convey a message. Now, ordinarily, how I park my car, if I double park or I park without paying whatever is the fee to be paid, I'm not doing that to convey a message. I'm doing it because I'm lazy or I think I can get away with it or whatever it might be. So ordinarily, how I park my car, if I do it contrary to the rules, that's not an act of expression. But if I do it as a form of protest, I am intending by my act, says the court, to convey a message or convey meaning, and that means it's an act of expression. So you can see how broadly the courts have defined expression. Now, one of the real challenges here, of course, is one might say, well, everything I do that's at least voluntary or semi-conscious could be seen as an act of expression. How I dress, how I walk, any of these things could be, somebody could look at me and say, oh, I can tell something about him because of how he carries himself in the world. Now, if we were to consider any of those acts to be acts of expression, then of course we'd really just be talking about the right as a general liberty to do whatever I want to do. And then, of course, everything would be resolved under Section 1. So there has to be some subset of human action that we call expression that doesn't include everything or most things. And again, that's the court's attempt to say, well, if I'm intending to convey a message to an audience, that should be enough. Now, I would add to that maybe what's really important in an act of expression is not just that I'm intending to convey a message, but part of that intention is I want or need the audience to recognize that I'm trying to convey a message to them, so they will look at whatever my act is as something that carries meaning and try to understand or interpret it. So when I use words, it's easy. I mean, when I use language that's familiar in some way, people know I'm trying to convey something to them. I might not be successful, but at least I am signaling to them that my act is meaningful or intended to be meaningful and asking them to look at my act in that way and try to understand what I'm saying.
So if we're looking at Irwin Toy, what was at issue was a provision from the Consumer Protection Act in Quebec, 248 at the time, that says that no person may make use of commercial advertising directed at persons under 13 years of age. So we are telling somebody that you cannot do something. And if we look at this matter coldly, it does not really look like a freedom of expression case.
Yeah, no, I agree. And I think that's a good point. I mean, the first thing the court had to think about it, and they had addressed this to some extent in the previous judgment, the Ford case concerning Quebec's commercial sign law. And that was whether commercial speech, whether advertising itself should fall within the scope of freedom of expression. Because there were many arguments that it shouldn't. If you think, for example, that freedom of expression is principally about the political process, ensuring that the kind of political conversation occurs that is necessary to a democratic form of government, then it's not obvious that commercial advertising would fall within the scope. Or another argument around commercial advertising was, well, advertisers aren't really expressing themselves. They are molding this message in a way to try to influence audience behavior. The corporation is not expressing its own views, feelings, whatever it might be. The Supreme Court of Canada rejected those arguments. It said freedom of expression is not just about political speech. It's broader than that. It's concerned with individual self-realization. It's concerned with the development and growth of truth or knowledge within the community. And even if it's true that a corporation is speaking in order to generate profit, and we may not be fully comfortable at calling that self-expression, nevertheless, there's an audience. And the audience has an interest when we're talking about freedom of expression in hearing what others have to say and reflecting upon it and making their own judgments. So the courts emphasized when talking about commercial expression, both in the earlier Ford case, but also in Irwin Toy, that there was something important or valuable about the audience interest here in hearing what others might want to say to it or to them.
In Irwin Toy, they did say that commercial speech is a protected form of expression.
That's right. And I think that we can understand advertising takes many shapes and forms. You can think of ads that have a lot of information within them. The classified ad, I'm wanting to sell my used car, and I provide some details about its shape, the model, and so forth, mileage or whatever may be on the car. And, somebody who reads that can think about, oh, is that what I want, and reflect upon it. There was an early case, too, about commercial speech involving the question of dentists as a profession being able to advertise. And the court said that they should at least be able to advertise things like their opening hours, the language that they provide services in, and so forth. So you can see that some ads can provide information that might actually be useful for an audience. But an awful lot of advertising is not that. And it takes the form of what we call lifestyle advertising, where there's just an attempt to associate the product with an image. And the ad only really works if the audience doesn't think carefully about it. So ads take many, many different forms. In Irwin Toy, the court said anytime an act is intended to convey a message to an audience, meaning to an audience, it's an act of expression that falls, at least initially, within the scope of Section 2B. In a sense, what it does is protects a communicative relationship. That's what's being protected here. It's not just leave me alone, don't interfere with me state. It is, here is a relationship that the state should not interfere with. I have a right to engage with others and to hear what others have to say. What's really important about Irwin Toy is that, well, it was not the first freedom of expression case to reach the Supreme Court of Canada. As we mentioned, the Ford case, there was a case about labor picketing called Dolphin Delivery that preceded Irwin Toy. But it was the case where the Supreme Court decided that this would be a good moment to set out a general test for what counts as a breach of Section 2B, and to say a little bit about, in very general terms, how they would approach limits to the freedom of expression right under Section 1. So I can go through the various steps that the court laid out for determining when Section 2B has been breached.
We love criterias. We love step by step.
Yeah. Here's what the court said about Section 2B. So the first question to be asked is the particular activity that it is claimed has been interfered with or restricted by some kind of state act, and in a case like Irwin Toy, by legislation, is it an act of expression? So we've talked about that, and the court has said, if the act is intended to convey meaning to an audience, it is expression. Now, However, the court said, in this case, if the act of expression takes a violent form, then it will not fall within the scope of Section 2B. Now, I think the court recognized that having defined expression so broadly, it was always possible that somebody might come forward and say, well, this act of terrorism or this assault, I engaged in it in order to convey a meaning or message. And if you think about acts of violence, we talk about meaningless acts of violence. Well, I guess implicit in that idea is sometimes we see acts of violence as carrying meaning. This exception does not extend to advocating violence. So if I express some sympathy or I say, yeah, the time has come to, overthrow the state or whatever it might be, it's only when the act itself is an act of violence, when the expression takes the form of violence. So when I assault somebody or I murder them, whatever it might be. So that's an important clarification. For example, the Keegstra case, a case in which the Supreme Court of Canada upheld the criminal code ban on hate speech. So initially in that case, the court seemed to say that this exception only extended to acts of violence and not to threats of violence. But subsequently in the Quadja case, the court said, no, it does include threats of violence as well. Now, of course, one might say, well, why was this necessary? Because we have the limitations provision. So surely, even if we said a terrorist act is an act of expression, there could be no question that under Section 1, restricting it would be justified. But I think there is some awkwardness or embarrassment to the idea of saying, yes, this is expression, fundamental right or freedom, and it just happens to interfere with some other right or interest, and therefore we can restrict it. I don't think anybody felt very comfortable with that. But I actually think if you hold to the view I expressed before, that we understand freedom of expression to be a relationship between speaker and audience, then violence, of course, is a negation of that relationship. It's not trying to engage the audience. It is trying to dominate, assert, do harm to the audience. So if you understand freedom of expression as a relationship, I think it makes more sense to say, yes, of course, an act of violence should not count as an act of expression, even though others might understand that it carries some kind of meaning. So anyway, that's the second step that the court said in Irwin Toy. They say, first, act of expression defined broadly, but that doesn't include expression that takes the form of violence, if we want to call that expression. Now, in a subsequent case involving a noise bylaw in Montreal, the court added to this second exception the location of expression. And really what that was all about, everybody has a right to communicate on government-owned property that is generally open to the public for communication. So streets, park, the legislative grounds, whatever it might be. But they don't have a right under Section 2B to communicate on government-owned property that is not generally open to the public for communication, and in which that kind of openness would be incompatible in a fundamental way with the use of the property. I don't get to go to the Prime Minister's office and communicate with him, breaking in, or anybody's office when they need some kind of privacy or control over the space to conduct their job. So that got added to that test.
Basically, what the court did in Irwin Toy is said, yes, what you are doing as advertisement is protected speech. We're going to put a scope. We're going to put some kind of a definition. We're going to tell people what to expect when we are trying to define expression. But at the end, even if they say it's protected speech, they did say something else.
Let me try and summarize the three questions that get asked as part of this Section 2B test set out by the Supreme Court in Irwin Toy. So the first, is it an act of expression? In other words, is the act intended to convey meaning to an audience? Even if it is, if the expression takes a violent form, it's not protected. And if it occurs in certain locations, it's not protected. And then there's a third question, and this is still part of the Section 2B test. The court says sometimes the restriction has as its purpose the restriction of expression. It's aimed at suppressing a particular message, the content of expression. Other times, there may be a law that is not intended to suppress expression, but it has the effect of doing so. If you define expression as broadly as the Supreme Court has defined it, any act that's intended to convey a message, illustrated by that example of parking my car, might not ordinarily be an act of expression, but if I'm doing it to convey a message, the consequence of defining expression that way means that, in theory, almost any law that's restrictive in character could be a restriction on expression if I've chosen to express myself in that way. So the court says if the purpose of the law, of the state act, is to restrict expression, a particular communication, then we automatically have a breach of Section 2B, and we'll have to go on to Section 1, the limitations stage. On the other hand, if the law's purpose is not to restrict expression, although it is argued that it has the effect of doing so in this particular situation, then the person who is making the argument that his or her expression has been restricted by this particular measure will have to show that his or her expression advances the values that are said to underlie our commitment to freedom of expression: self-realization, advancing democratic government, the growth or development of truth. In the case we were talking about earlier, the Montreal Noise Bylaw case, a strip club that was projecting who knows what out in the street, presumably the sound within the club, or maybe yelling out girls, 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 whatever it might be. Nevertheless, the court said, okay, the point of the noise bylaw in that case is not actually to restrict any particular meaning or message, it's just to prevent loud noises being projected out of the street. So the purpose is not to restrict expression, but the effect in this particular case is to do so. So it falls upon the strip club to show that their expression advances one of the values underlying the commitment to freedom of expression, and the court says it does, because it advances self-realization by informing people out on the street potentially about a leisure activity. Well, all I can say is, if that counts as advancing the values that underlie our commitment to free speech, then surely anything that we call expression does. I think what's really going on is when we're talking about a restriction that merely has the effect of restricting expression, we're talking then about a situation where an individual can presumably or ordinarily express the same message in a different way, a different place, a different time. And so it's not a simple direct expression on a particular kind of communication, a ban on hate speech, a ban on sexually explicit imagery, a ban on commercial advertising of different kinds. It's not an outright ban on a particular category of speech. Rather, it's a restriction on where, when, how that speech occurs. And in most cases, there will be alternatives. I can communicate this message somewhere else at a different time in a different way. Potentially not as severe a restriction on expression. Now, of course, it might be that there is really only one effective way for me to convey my message, and this measure, which may not be directed at the content of my speech, has the effect of silencing me preventing me from being able to express effectively the message I want to communicate.
But the severity of the restriction is not a criteria.
Well, if the speech can be expressed in other ways at different times, then it may be. We say, okay, you can't communicate in a loud way at this point or in this way, is not such a large problem. And so that's a factor in determining whether or not the restriction is reasonable. In the Irwin Toy case, then, when applying that test to the facts of the case before them, the court said, well, yes, this is expression. The advertising that is caught by this law has as its purpose the communication of a meaning, of a message to an audience. It's not violent in its form. And then thirdly, the purpose of the restriction is to suppress communication of a particular kind. It's not a sort of incidental effect. That's the purpose. So therefore, there is a breach of Section 2B, and therefore we have to go on to Section 1. So part of what needs to be kind of worked out with Irwin Toy is to recognize that the court used this case as an opportunity to articulate a general test for whether or not there's been a breach of Section 2B. It was easy to apply this test to the facts of the Irwin Toy, case itself. So then we move on to Section 1 and we consider whether or not this restriction on advertising directed at children under the age of 13 is reasonable and demonstrably justified in a free and democratic society. That's the general test. Any restriction has to be prescribed by law. That's a kind of threshold question. And in this case, that's easy. The restriction has legal form. It's in the form of a statute supported by different regulations that elaborate on the statutory provisions. So we have a restriction prescribed by law. We go on to, is the restriction reasonable and demonstrably justified in a free and democratic society? Is there a substantial and pressing purpose behind the restriction? Is the restriction rationally connected to its object or purpose? And does it restrict the right of freedom as little as it needs to advance that object? And then there's a kind of final question about the trade-off between the degree of interference with the right versus the importance of what's being pursued by the restriction.
Proportionality.
Exactly. That's the term we generally apply to that. In this particular case, then, the court says, well, there is a substantial and pressing purpose here to protect young people from manipulation. And then they say, is there a rational connection between this measure? And does it restrict the freedom as little as it needs to? Now, one argument made by Irwin Toy, by the advertiser in this case, was, well, this restriction is like overly broad. It's restricting more than it needs to advance this objective of protecting children from manipulation. And they said because there are studies that show quite clearly that younger children, between the ages of 2 and 7, I forgot the exact parameters, that they really don't recognize the intention, the attempt to persuade them. They don't recognize that. And so we may accept that children of that age are appropriately protected from advertising. It's manipulative in character. The studies are less clear about older children up to the age of 13. Somewhere in this age spread, children develop a greater capacity to recognize what advertising is trying to do and that it's about trying to persuade them to buy a product, or at least more reasonably nag their parents to buy a product, whatever it might be. And so their argument was, it's overly broad. It restricts more speech, more advertising than it needs to advance this objective, protecting children from manipulation. And here is where the court says, well, we need to show some deference to the judgment of the legislature when they're assessing this kind of complicated, rich social science evidence. And we also should show some deference to the legislature when it's attempting to protect a vulnerable group. So the case was also important for signaling that there are moments or times in which the court shouldn't just be second-guessing the legislature. The idea of the advertiser's pursuit of profit versus protecting children from manipulation. And in fact, for me, there is no weighing or balancing, and that to me raises actually a more fundamental question about whether or not this should have counted as protected speech in the first place. I mean, as we talked about earlier, if we're discussing the idea of a relationship between speaker and audience, well, this advertising is aiming to and has the effect of influencing children. That's the point, the manipulation here, without them recognizing what it's aiming to do. So I actually think that there is no meaningful balancing that occurs under the Section 1 analysis because we're actually not sure that should count as expression in the first place. Now, again, that's not how the court analyzes things in this case and in subsequent cases. They always define expression broadly, any act that conveys a message and not violent in form, and rely on Section 1. But buried in the Section 1 analysis might be all of these considerations about, is this really important or valuable expression in some way? When we get to Section 1, some forms of expression may be more valuable than others, and that can play a role in the proportionality analysis. So the court says, for example, political speech, that's core value expression. That clearly advances the values that we think underlie our commitment to free speech, in particular, the importance of speech to democratic governance. So it's hard to justify a restriction on political speech, says the court. But when we get to obscenity or pornography, or when we get to commercial advertising, or when we get to hate speech. Those forms of expression, while they might be protected under Section 2B, don't, according to the court, as clearly advance the values that underlie our commitment to free speech, and so it may be easier to justify their restriction under Section 1 test.
Professor Moon, the court knew when they rendered the decision in Irwin Toy that Keekstra was coming as well. In 1990, Supreme Court of Canada, Mr. Keekstra, teaching high school children about anti-Semitism, and he was charged under Section 281.22 of the Criminal Code, where he did unlawfully promote hatred.
Mr. Keekstra, as you say, was a school teacher for many years, taught about the great Jewish conspiracy to undermine Christian civilization, etc., and the students were expected to parrot his views. It was really alarming. Now, one might say the simple answer to this is fire him as a teacher, which of course he was.
He was fired in 1982, having been a teacher since 1974.
So I think the province was somewhat embarrassed that this had gone on for so long, and I think that's what really prompted the criminal prosecution under the hate speech provision. And so, of course, the first line of argument in a case like this is that the hate speech provision is unconstitutional, that it breaches Section 2B of the Charter, and it can't be justified under Section 1. So anybody representing somebody like Keekstra, that's the first argument they're going to make. So without addressing the specific facts of his case, the court has to think about whether or not this is a justified restriction on expression, or whether it restricts expression, and if it does, whether it's a justified restriction. So that's the issue that goes all the way to the Supreme Court of Canada. The court goes into that case with, of course, the Irwin test in place. First question, does this law restrict expression? Well, hate speech conveys a message to an audience. Well, it's not violent in its form. It might encourage people to engage in violence. That's true, but it's not itself a violent act, says the court. And then the purpose of this law is to restrict a particular kind of expression, a particular message, a hateful message. So we have a breach of Section 2B if we are applying the Irwin Toy test, which the court does. Now, when they go to Section 1, the court adds something which I think was implicit in the Irwin Toy case. They adopt what we sometimes refer to as the contextual approach. They say, well, all forms of expression are protected under Section 2B, except violent forms. When we get to Section 1, some forms of expression are more valuable, more weighty than others, because they more clearly advance the values that underlie our commitment to freedom of expression. And so it is going to be harder for the state to justify the restriction of those forms of expression. So the court says political speech, that's valuable speech. If the state is going to restrict that, it's going to have to make a very clear, strong case under Section 1.
What about commercial advertising?
Commercial advertising is not core value expression. And how they at least ostensibly measure this is by saying, to what degree or in what way do these forms of expression advance the values that underlie our commitment to free speech? So when the court gets to hate speech, it says, yes, it's protected under Section 2B, but it's not core value speech. And the court says it's not core value because it almost invariably involves claims that are false, and so does not work towards the realization of truth. It undermines democracy and the standing of some in the community as citizens, and it undermines their self-realization or their self-expression. So Chief Justice Dixon, writing for the majority in that case, starts off by saying this is less valuable expression. The state still has to justify its restriction under Section 1, but it may be easier to do so. And the court then goes through the various steps of the Oakes test, emphasizing that there's an important objective, protect society from the spread or promotion of hateful views, that the law is very narrowly drawn, that the law restricts only a very narrow category of extreme speech. And so it's quite narrowly drawn, says at least the majority in that case. And that's important because we hear a lot of debate about hate speech, and a lot of people say, well, this was really hurtful or offensive speech, and consider that to be hate speech. And it's really important to remember there could be a lot of bigoted speech that goes on out there in society, but it's not necessarily extreme enough to count as hate speech falling within the scope of this criminal code prohibition.
Expression, no matter how offensive, unpopular, or disturbing, cannot deprive of its Section 2B protection.
That's right. I mean, we live in the world where, of course, people say things that are hurtful or offensive, and the idea that we might want the state to expunge all of that, well, that would be a really troubling intervention. We hope that people don't say things that are hurtful, offensive, and whatever, but the idea that we might have a law that sought to remove all of them from our public conversation would require extraordinary intervention by the state. And because they're so widespread, it's really important that we try to address them rather than try to expunge them from public conversation. A majority of the court says this restriction on expression is justified because it is advancing an important goal and because it's confined to a narrow category of extreme speech that can, in fact, cause harm. Now, there's a whole other debate to have.
There's no doubt that Irwin Toy is a landmark decision. It's still used today. It's still cited by the courts today. How do you think it has impacted Canadian society?
Well, I mean, I think in a couple of ways. I mean, one is, first of all, the court makes clear that they understand the scope of freedom of expression very broadly. So it does include commercial advertising, for example, and it turns out it includes, speech that many of us might regard as offensive or hurtful in character. So that's the first thing. They've defined it very broadly. As a practical matter, I suppose within the courts, it means that almost always, the significant analysis of whether or not a law is constitutional, a law that addresses issues of expression and restricts them, the significant analysis is all occurring under Section 1. And sometimes these very general tests may serve to conceal what's really going on and what our real concerns and fears are. So I don't know. It would be a real challenge to try to define the category of expression more narrowly. I think the court might have tried to do that. And as I say, I do wonder about a law that aims to restrict advertising directed at children that the court believes, that the state believes, and obviously the court accepts this, is manipulative in character, whether that should in fact count as expression in the first place.
I'm exiting a Walmart. I am in the parking lot. I start running after somebody that is putting stuff in his car. I go 2 inches from his nose and I start yelling at the person. Irwin Toy tells me I'm in a free country and I can say whatever I want. And then I start telling him whatever I want. What should that person answer me?
A variety of things there. The first thing is about audiences. Well, we cannot and should not try to create a kind of public sphere where people don't have to hear what they don't want to hear. I worry about this because sometimes you hear this argument made, well, if I don't want to hear it, I shouldn't have to hear it. I shouldn't be confronted and harassed, and I shouldn't have somebody follow me around, but we don't want to cleanse the public sphere of all communication of any kind that I might not want to hear. So the audience has some rights, and they should be able to walk past or walk away from communication they don't want to hear. So that's one thing. If I'm right up to you nose to nose, and I'm kind of on the edge of either harassment, maybe not assault, but it's on the edge of that. So there are some difficult lines there. The person you're, following around should be free from that. Now, again, line drawing in those cases is difficult to know. Well, when has the line been crossed? Individuals can and should be protected from harassing speech. I mean, we're already witnessing this whole debate about bubble zones, initially around abortion clinics, and now in Ontario in different places around places of worship and synagogues in particular. And that's a highly contentious debate.
What about silence, Professor Moon?
It can be. Because by my silence, I can intend to convey something. I mean, a moment of silence, for example, is, in a sense, an act of expression. So there are ways in which silence can be constructed as conveying or communicating a message. But the other thing, and this is distinct, I think, is that freedom of expression is also understood to protect an individual from being compelled to speak when they don't want to speak. So if the state requires me to convey a message of some kind that it's not my message or I don't want to convey, being forced with some threat of punishment to convey that message counts as a breach of freedom of expression. And I think the reason for that is because expression is so central to us, to our identity, to be required to say something that is not what I want to say, not my words, is deeply invasive. So there was a very important case that came out of the U.S. early on that really began this idea of compelled speech. A case called West Virginia and Barnett. And basically it was near the end of the Second World War. And in West Virginia, kids in the public school system were required to salute the flag. And a group of Jehovah's Witness children declined to do so. And the punishment for not doing so was incredibly extreme. You would not only be expelled from school, but if you're expelled from school, you'd be considered a delinquent. The kids could be taken from their parents. The U.S. Supreme Court said it was an interference with this fundamental right to free speech. It could have also been an interference with religious freedom to be compelled to express a view that was not your view. Now, is silence communication? As I say, silence can be communication. And if it is, like as in a moment of silence or a vigil of some kind, then that's an act of expression. It would be protected. But in this case, it's not that silence is expression. It's that I shouldn't have to say something I don't want to say. And the state should not compel me to do so. And I think, again, the reason for that is because speech is so important to my sense of who I am, how I present myself in the world, it's really invasive when I am required to utter words that are not mine and that don't represent my views.
So if the federal government decrees a minute of silence every Friday morning...
Well, I mean, they can decree that. If they punish me for not honoring it, that might be different.
Professor Moon, thank you very much for sharing your knowledge with us. Any last words? Because I don't want to stop you from saying whatever you want.
No, I have many words, but and many things to communicate, but I think you've given me a fair opportunity to set some of this out, and I'm really grateful for you inviting me to do this.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Kazirer, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakin, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.